questions or anything like that.
Mayor.
Question. Would it be appropriate for us to ask you your opinion of the merit?
It wouldn't be appropriate because I have not reviewed, first of all, there are facts. I have only been the city attorney since February. There are facts that are alleged in here that predate my tenure as city attorney. For that reason, I can't make any judgment as to the factual merits of it. And I would not want to give an evaluation of the legal merits of it until I have researched all of the issues.
Do we have sufficient information to make a decision tonight?
Commissioner, that's your call. The mayor reminds me it's a reasonable person standard here.
I think, as Commissioner Sellers pointed out, so there may be some question as to the method behind any investigation. I do have some questions. I mean, if we said tonight, well, there's some merit here, and we probably need to look into to clear all those involved. What would be the method? That would we adopt that tonight, or would we just say, yes, there is some thought here to put into this and go on to the next regular scheduled meeting and identify the method? And I guess the beginning, the middle, and the end is what we need at this point, because we don't really have any of that defined. The process isn't here. We've got a goal that we want to achieve, but we don't have a map to get us to that destination.
Based on the information you have right now, you have to decide whether, using a reasonable person standard, whether on its face, out of hand, the complaint has no merit and you want to dismiss it. If you decide that it does have merit, that you believe that there has been a violation of the ethics ordinance and you're prepared to make that determination, then you need to do that. You would have to determine then what the prescribed penalty would need to be regarding any kind of violation. If you determine that you need more information, that you don't have enough information to make a decision tonight, then it is completely within your authority to prescribe the investigation procedure. That what you want, how you want it to be conducted. If you want the statements to be done under oath, whether you want there to be, first of all, you need to decide who you want to do the investigation. Then I think it's entirely within your discretion to decide what procedures you want to have used. But I'm recommending that you do at least two things. That you require a formal written evaluation of the merits, both factually and legally, to you in order to help you make your decision ultimately, and that you set a date certain for when you want that information to come back.
That's you're saying, suggesting that we do have an investigation. That's kind of what I'm getting. In between now and maybe the next meeting, do we need to prescribe some method? Would it be, I guess my question, would it be something we should do maybe to put this off till Monday's meeting to come up with the method of how we're going to do the investigation and what is going to be the end result of that investigation? Is that something we should do?
You can do that. You can defer it, but ultimately you have to make a decision under the ordinance.
I think we need to act on this tonight. We need to set a date. I've got a date. I would say May the 7th. That gives 3 weeks for an investigation. If the investigation is not completed at that time, then if Paula does the investigation, then we could give her an extension of time if we vote on it. But we need to go ahead and take care of this now. We need to go ahead and do the investigation and get it done.
Well, I guess my issue with that is, and I agree with you that it doesn't need to linger by any means, but at the same time, when you give instructions to conduct an investigation has to follow certain guidelines, and as of right now, we don't have any guidelines in place, so the guidelines will be made up as you go. And is that properly stated?
Other investigations that are conducted, for example, pursuant to the personnel manual, are done informally. You can elect to, you can define the process, because it's you that has to make the decision. And so, you need to feel comfortable with the process, you need to feel comfortable with the investigator, and you need to feel sure that at the end of the day, when you're ready to make a decision, that you've got all the information that you need.
The question would be, and I apologize, the question would be to the rest of the commission then, if there was an investigation, there was merit that there needed to be an investigation, are we comfortable with the process now? And that probably needs to be the question asked of everybody here tonight. Are you comfortable with the process that we have or have not got described to us?
Okay.
If we're going to set any definition on the process, I want this commission to vote on tonight that all testimony will be taken under oath and be done in the presence of a court recorder or stenographer or whatever their titles are today. But I don't want anybody giving testimony here without being under oath, because they can say anything they want, may not be held accountable for it. Whereas under oath, there's always perjury laws, and I would assume that they would apply in a situation like this.
Yes.
Okay. And then,
If they take an oath, yes.
okay. I mean, that's what I want to make sure. Okay.
I'd like to take a 5-minute recess to have consultation with somebody. Like this. Yes, it is.
Take a 5-minute recess.
5 minutes, I can speak to someone.
Is there a second? All those in favor of a 5-minute recess?